Good afternoon, and welcome back to the saga of the greatest patent story ever told. Fast forward to 2007, and where on October 26th, a lawsuit was filed in federal court styled as Christine Anderson versus the state of New York. The short of it is that Miss Anderson was a staff attorney at New York's Appellate Division First Department Departmental Disciplinary Committee, or the DDC as we call it, who allegedly witnessed injudicious actions of whitewashing and rubber stamping of attorney complaints at the DDC. Miss Anderson specifically singled out the I View It attorney complaints against Kenneth Rubenstein, Raymond Joa, Stephen Crane, the law firm of Proskauer Rose LLP, and the DDC's chief counsel, Thomas J. Cahill. I View It followed Anderson in filing a lawsuit on December 12, 2007, the amended complaint of which claims up to $1 trillion in damages. Since then, 8 other cases have been filed in the district court, all claiming similar whitewashing of attorney complaints and corruption in New York courts. I View It defendants filed motions to dismiss, and on behalf of I View It, I personally filed opposition papers, and the battle had begun. Until the district court summarily dismissed all the related cases on August 8, 2008. As a further description of the series of events in the district court, what follows is an open letter to the United States Congress seeking federal intervention in the DDC's and the New York court's wicked ways. And I quote, "By way of introduction, I am a co-plaintiff in Elliott Bernstein versus the State of New York, and I write to inform you, as members of the Judiciary Committee, of the actions of a judge or persons acting on her behalf, in which the committee approved to adjudicate cases in the United States District Court for the Southern District of New York. Never have the plaintiffs of the related cases or their kitchen cabinet of attorneys seen such an abusive process, an ignorance of the rule of law, and the denial of due process combined with a complete defiance of all rights afforded to litigants under the Constitution of the United States." The judge in question, the Honorable Shira A. Shinlin, accepted as related a series of cases in which named defendants included, among others, New York's DDC, and in some cases, the State Commission of Judicial Conduct. For your benefit, the DDC oversees the discipline of attorneys, and the SCJC oversees the discipline of judges in the state of New York. Or, that's how it's supposed to work in theory. All of the lawsuits filed showed clear and convincing evidence of corruption by both the DDC and the SCJC in covering up criminal and ethical violations of attorneys and judges, with allegations ranging from state judges in contempt of executive order, the concealment of evidence by the SCJC, the obstruction of justice by the Court Inspector General, the sexual assault by a judicially connected attorney who proclaims that he receives favors from judges, crimes involving theft of $100,000 in 9/11 Red Cross donation monies, the pilfering of estates by attorneys, and the sabotage of backbone-enabling video and imaging technologies. To continue, Judge Shinlin, or again persons acting on her behalf, accepted all of these cases as related, then dismissed the complaints en masse. Some plaintiffs were in the midst of filing their amended complaint. In other cases, plaintiffs were stopped from serving defendants in their recently filed amended complaints. And still further, some plaintiffs had not yet served some defendants at all. Judge Shinlin, or persons acting on her behalf, set up the related plaintiffs, accepted their cases, then, without warning, she, or again persons acting on her behalf, dismissed 5 out of the 6 cases in one opinion. The I view it opinion and order was delivered separate and apart, where together, with clear and convincing evidence referenced above, and to paraphrase the words of Senator Dianne Feinstein in the 2007 Alberto Gonzalez hearings, there is something rotten in Denmark. This sense of justice by a federal judge or persons acting on her behalf who was sworn to uphold the Constitution is tantamount to a travesty of justice at the minimum, but more likely no justice at all. In just one decision, Judge Sheindlin, or persons acting on her behalf, has eliminated the most important safeguarded principle in the Constitution, the right of due process and the right of every litigant to have their day in court. More specifically, Judge Sheindlin's opinion and order guts the plaintiff's First Amendment rights to petitions one government for grievances and redress, thus leaving this right meaningless, and permits blatant and overt corruption and misconduct, as well as other constitutional violations, by the very state entity set up to respond to grievances within the state of New York. This is the first instance. In the second instance, it does so in a matter which has eliminated any opportunity to be heard in the federal system and done contrary to U.S. law, the Constitution, and all sense of fair play and justice. Bending to powers unknown, or by persons acting on her behalf, Judge Sheindlin's opinion and order lacks the courage, the strength, and the sense of ethics as a result of the pressures imparted to undertake such a serious problem in the state of New York, to wit, the corruption of judges and attorneys and the protection of their conduct by the DDC and the SCJC. Consequently, considering the above set of circumstances, the state of affairs in New York will never right itself absent federal intervention, and the related plaintiffs request an immediate interview before select members of the committee where, supplied with more information and face-to-face meetings, it will be crystal clear to all the need for congressional intervention by means of public hearings and subsequent investigations. On behalf of the related plaintiffs, I will follow up with your counsels to arrange a mutually convenient time to meet with the committee. Thank you, and stay tuned for another episode of the greatest patent story ever told as the related cases proceed to the United States Court of Appeals for the Second Circuit. By the way, the USPTO notice of appeal has since been hijacked en route. Thank you very much. And she has quite a story of her own.